All rise. Veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. La Joint Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Good morning, everybody. Madam Registrar, could you call the case, please?
Good morning, Your Honor. This is case number IT 0474A. The prosecutor versus Mr. Prlić, Mr. Stoic, Mr. Prlić, Mr. Petković, Mr. Ćorić, and Mr. Prlić.
I thank you. And I'm pleased to recognize the presence of the Deputy Registrar of the Tribunal today. Let me now ask for the appearances of the parties, starting with the prosecution.
Good morning, Mr. President. Your Honors, for the prosecution, appearing as myself, Douglas Stringer, with Laurel Begg, Barbara Goy, Katrina Gustafson, Aditya Menon, and Janet Stewart.
Thank you very much. And appearances for the defense. I note, however, that Mr. Prlić has waived his right to be present at the pronouncement of the appeal judgment today. So I'll just proceed to acknowledge the presence of the defense counsel. For Mr. Prlić.
Good morning, Your Honor. Michael Karnavas and Susanna Tomanovic.
Thank you. For Mr. Stoic.
Dobro jutro, čast.
Good morning, Your Honor. Appearing on behalf of Mr. Stoic, Ms. Senka Nožica, and our legal consultant, Aidan Ace. Kako god se taj zvao. Good morning, Your Honor. Good morning to you and to all those present in and around the courtroom. On behalf of Mr. Prlić, Ms. Nika Pinter, and Ms. Natasha Favo-Ivanovic from Paris, appearing.
For Mr. Petković.
Dobro jutro, časni.
Good morning, Your Honor. On behalf of Mr. Petković, Ms. Alaburic, and Mr. Lazic.
Thank you. For Mr. Ćorić.
Za Valentina Ćorića.
Good morning, Your Honor. Lead counsel Diana Tomašegović-Tomić and co-counsel Mr. Dražen Plavic, appearing on behalf of Mr. Ćorić.
Hvala lijepo, dobro jutro, časni sude.
Good morning, Your Honor. On behalf of Mr. Prlić, Mr. Ibrahimović, and Mr. Sahota appearing.
Before I proceed any further, I would like to confirm with the defense appellants whether they can all follow the proceedings in a language that they can understand.
Good morning, Mr. President and member of Chambers. I'm able to follow.
Thank you.
Language which I have understood.
Thank you. Mr. Stoic.
Dobro jutro, časni.
Good morning, Your Honor. Everything is fine. Thank you.
Hvala, razumijem.
Thank you. I can follow completely.
Dobro jutro, časni.
Good morning, Your Honor. I can follow.
Mr. Ćorić.
Dobro jutro, časni sud.
Good morning, Your Honor. Everything is fine. Thank you.
Good morning to all of you. The appeals chamber is sitting today in accordance with Rule 117D of the Tribunal's Rules of Procedure and Evidence and the scheduling order issued on 5th October 2017. This will be the last sitting of and the final judgment pronounced by the International Criminal Tribunal for the former Yugoslavia. This has been a long and complex case, with much time having passed since the trial proceedings began in 2006, and since the appeals chamber was first seized by a notice of appeal in June 2013. The appeal hearing in this case was held between 20th and 28th of March of this year. The appeals chamber would like to thank the parties for their cooperation and professionalism, as well as all sections of the registry for their dedication and support. I will now summarize the findings of the appeals chamber in the case of Jadranko Prlić, Bruno Stoic, Slobodan Prlić, Milivoj Petković, Valentin Ćorić, and Berislav Pucic. Not every issue discussed in the judgment will be addressed in this summary. Also, and very importantly, this oral summary does not constitute any part of the authoritative written judgment of the appeals chamber, which will be distributed to the parties at the close of this hearing. The events giving rise to the appeals in this case occurred between 1992 and 1994 in 8 municipalities and 5 detention centers in the territory of Bosnia and Herzegovina that was claimed as part of the Croatian community and later the Croatian Republic of Herzegovina. Prlić, Stoic, and Ćorić served in the government of these entities respectively as President of the Government, Head of the Department of Defense, and Chief of the Military Police Administration, with Ćorić later being appointed Minister of the Interior. Prlić and Petković served at different times as the Commander or Chief of the Main Staff of the Bosnian Croat Army, or the HVO, as I will be referring to it. Pucic served as an officer in the military police of the HVO and was later appointed as the head of its Exchange Service and Detention Commission, bodies which were mandated with the responsibilities in the areas of detention and prisoner exchange. Prlić also served as the Assistant and then Deputy Minister of Defense of Croatia, before later returning to Croatia as an advisor to the Croatian Minister of Defense. The trial chamber found that by mid-January 1993, a joint criminal enterprise, or a JCE as I will be referring to it, had come into existence that was aimed at creating a Croatian entity in Bosnia and Herzegovina that would facilitate the reunification of the Croatian people. According to the trial chamber, this joint criminal enterprise had as its common criminal purpose the, quote, domination by Croats of the Croatian Republic of Herzegovina through ethnic cleansing of the Muslim population, unquote. The members of this JCE were found to have implemented an entire system for deporting the Muslim population of the Croatian Republic of Herzegovina. This system consisted of a wide range of crimes. That is the removal and placement in detention of civilians, murders and destruction of property during attacks, mistreatment and destruction of property during eviction operations, mistreatment and very harsh conditions of confinement in HVO detention centers, the use of detainees on the front lines for labor or as human shields, and the removal of detainees and their families to other territories once they were released from detention. The trial chamber found that thousands of persons lay victim to these acts of violence, which were committed in an organized fashion by the military and political forces of the HVO. The trial chamber concluded that all 6 defense appellants were participants in the JCE. They were convicted for committing grave breaches of the Geneva Conventions, violations of the laws or customs of war, and crimes against humanity, including murder, persecution, imprisonment, unlawful labor, forcible transfer, deportation, inhumane acts, inhuman treatment, extensive destruction of property not justified by military necessity, and destruction of institutions dedicated to religion or education, and unlawful attack on civilians, and lastly, unlawful infliction of terror on civilians. In addition, under the 3rd category of JCE liability, Prlić, Stoic, Petković, and Ćorić were also convicted of rape and sexual assault. And defense appellants, with the exception of Prlić, were found guilty of plunder and extensive appropriation of property. Ćorić was also found to bear superior responsibility for certain crimes that occurred in 1992. The trial chamber sentenced Prlić to 25 years of imprisonment, Stoic, Prlić, and Petković to 20 years each, Ćorić to 16 years, and Prlić to 10 years of imprisonment. All 6 defense appellants, as well as the prosecution, have lodged appeals against the trial judgment, and I now turn to these appeals. Starting with the fairness of proceedings, Prlić contends that he was systematically denied adequate time and facilities to question witnesses, while Stoic alleges that the trial chamber erroneously relied on evidence related to Franjo Tuđman and other senior leaders of the Republic of Croatia who passed away before the proceedings started. The appeals chamber finds no merit in either contention and dismisses them accordingly. With regard to the indictment and other fair trial issues, Stoic and Petković allege that the trial chamber impermissibly altered the prosecution's charges against them by contemplating a JCE other than the one pleaded in the indictment. Petković adds that the prosecution's final trial brief indicated that it was pursuing a narrower case than the one for which he was convicted. The prosecution responds that the trial chamber did not depart from the indictment, that the prosecution's opening statement, presentation of evidence, and mid-case submissions were consistent with the indictment, and that its final trial brief did not alter the notices of its charges. The appeals chamber observes that the indictment clearly put the defense appellants on notice of the crimes and modes of responsibility with which they were charged. The appeals chamber further considers, Judge Pokar dissenting, that the prosecution's final trial brief, which did not expressly and formally withdraw any allegations, cannot reasonably be interpreted to mean that the prosecution was abandoning modes of liability charged in the indictment. The appeal chambers, therefore, finds Judge Pokar dissenting that Stoic and Petkovic have failed to demonstrate any error. Prlić also challenges three aspects of the notice of charges against him. The first and second challenges, alleging that the trial chamber exceeded the indictment in finding a state of occupation and in finding the extent of protections applicable to certain detainees, are unsubstantiated and unpersuasive. The third such challenge is that the trial chamber erred by considering that he contributed to the JCE by exercising his powers as Minister of the Interior, since this was not charged in the indictment. The prosecution responds that he was provided with clear notice that any defect was appropriately cured, and that in any event, Prlić's ability to prepare his defense was not materially impaired. The appeals chamber finds that the indictment was ambiguous on this point, thereby rendering it vague and defective. This defect was not cured through the prosecution's post-indictment disclosures. A defective indictment which has not been cured causes prejudice to the accused, and this defect can only be deemed harmless through a demonstration that the accused's ability to prepare his or her defense was not materially impaired. The prosecution has not met its burden in this regard. In light of the prejudice suffered, the appeals chamber grants Prlić's appeal in part, reverses the trial chamber's finding on his role in the JCE as Minister of the Interior as of 10th November 1993, and vacates his convictions in relation to his responsibility as Minister of the Interior based on JCE liability. I now turn to the challenges regarding admissibility and weight of the evidence as well as witness credibility. Prlić and Prlić contend that the trial chamber erred when it admitted and relied on extracts of Ratko Mladic's diaries while denying them the opportunity to reopen their case or tender evidence in response. Stoic adds that this constituted uncorroborated and untested hearsay evidence. The appeals chamber finds that they have not demonstrated that the trial chamber abused its discretion in admitting the extracts. Prlić never unconditionally requested that his case be reopened, and in any event, the trial chamber expressly permitted him to admit evidence to rebut these diary extracts, which he did. Prlić was likewise offered an opportunity to challenge these extracts. Neither Prlić, nor Prlić, nor Stoic show that no reasonable trier of fact could have relied on this evidence. Their arguments are dismissed. Prlić, Stoic, Prlić, and Prlić also contest decisions pertaining to the admission or assessment of evidence, including with regard to witness credibility and Prlić's own testimony. The appeals chamber finds that they fail to show any error with respect to Prlić's claim that the trial chamber failed to explain what parts of his testimony it found credible or not credible, and why. The appeals chamber finds that he does not demonstrate how the lack of a more detailed discussion would invalidate the trial judgment and therefore dismisses this challenge accordingly. I now turn to the legal requirements for grave breaches of the Geneva Conventions. The Appeals Chamber reverses proprio motu. The trial chamber's conclusion that an international armed conflict between the HVO and the Bosnian Muslim Army, the ABIH, only existed where active combat was taking place. The Appeals Chamber recalls that the temporal and geographic scope of an international armed conflict extends beyond the exact time and place of hostilities, and considers that the trial chamber's finding of an international armed conflict in specific parts of the Bosnian territory were sufficient for the grave breaches regime to be applied to crimes committed elsewhere in Bosnia and Herzegovina until the end of the armed conflict, so long as the necessary nexus to the armed conflict was established. With regard to the trial chamber's finding of a state of occupation, the Appeals Chamber considers that the trial chamber appropriately examined whether a state of occupation existed in the relevant municipalities at the time certain crimes were committed against protected persons in and protected property on occupied territory. The Appeals Chamber considers that occupation is a question of fact that needs to be examined on a case-by-case basis. The Appeals Chamber further considers that a power can, by proxy, exercise the authority necessary for occupation through de facto, organized, and hierarchically structured groups. There were numerous factors indicating that Croatia, through the HVO, had actual authority over the relevant municipalities, and the Appeals Chamber finds that Prlić, Stoic, Prlić, and Petković, and Ćorić have failed to show any error by the trial chamber in reaching this conclusion. The trial chamber also found that 2 locations in Vareš municipality were occupied after 23 October 1993, and the prosecution concedes that occupation was not proven at the time that certain property was destroyed and appropriated in these locations. The Appeals Chamber thus vacates the defense appellant's conviction for extensive destruction and appropriation of property insofar as these incidents are concerned. The trial chamber further found that the HVO detained 2 categories of Muslim men who benefited from the overarching protection of Geneva Convention 4, rather than being prisoners of war receiving the different protections under Geneva Convention 3. First, with respect to the Muslim members of the HVO, Stoic, Prlić, Petković, and Ćorić allege that war crimes cannot be committed by soldiers against members of their own military force. The Appeals Chamber considers that in this case, the trial chamber correctly took into account the allegiance of Muslim HVO members rather than merely considering their nationality. Since the detaining authorities' view of the victim's allegiance is a relevant factor in this assessment, the Appeals Chamber finds that no error has been demonstrated. Second, with respect to Muslim men of military age, Prlić, Petković, Ćorić, and Prlić submit that the trial chamber erred in finding that such men were not members of the armed forces. They refer to Bosnian law regarding reserve forces, as well as a general mobilization order. The trial chamber duly considered these arguments at trial. The appeals chamber further finds that a reasonable trier of fact could have concluded that the HVO failed to carry out individualized assessments of military-aged Muslim men within a reasonable time as required by law. Moreover, the trial chamber made findings demonstrating that such men were arrested en masse, together with Muslim women, children, and the elderly, and that all Muslims were detained and treated in the same manner irrespective of their status. The challenges to these findings are dismissed. Petković finally submits that the detention was necessary for security reasons and therefore justified under Geneva Convention 4. The appeals chamber observes that such a detention requires an individualized assessment that each civilian poses a particular security risk. The trial chamber concludes that the arrests were not justified and that the Petković orders to arrest these groups of Muslim men also ran afoul of Geneva Convention 4. Petković has not shown that the trial chamber erred in reaching these conclusions. I now turn to the underlying crimes for which the defense appellants were convicted. Before doing so, I note that Judge Liu dissents from all portions of the judgment dealing with the unlawful infliction of terror on civilians as a violation of the laws or customs of war, because he is of the view that the tribunal does not have jurisdiction over this crime and that the elements of this offense, as set out in the judgment, do not adequately define a criminal charge. Prlić appeals the trial chamber's finding that the HVO unlawfully imprisoned more than 1,000 Muslim civilians in houses in Prose Municipality and held them in harsh and overcrowded conditions. He argues that some Muslims might have gone to the houses voluntarily, that their relocation was necessary to ensure their safety, and that although restricted, they still enjoyed some freedom of movement and were not detained. The appeals chamber dismisses his first two contentions, which ignore the extent of the evidence relied upon by the trial chamber, or otherwise fail to show that no reasonable trier of fact could have reached the same conclusion. With respect to his third contention, the appeals chamber recalls that imprisonment and unlawful confinement can occur even when civilians are held in houses without guards or where they have some freedom of movement. In light of the findings that the HVO soldiers and military police arrested civilians, brought them to the houses, and remained present in these locations, the appeals chamber finds no error in the conclusion that these civilians were imprisoned and unlawfully confined. Even if their internment had been a necessary restriction on their movement under Geneva Convention 4, this would have been subject to strict rules and requirements, which the HVO failed to respect, thereby belying the true nature of the detention. Prlić's appeal is therefore dismissed. A month into this detention, the HVO forcibly removed and transferred Muslim women, children, and elderly persons according to the trial chamber. Prlić submits that the trial chamber wrongly found that they were forced to leave instead of considering that they may have left by choice, and that in any event the removal may have been necessary for security or military reasons. The trial chamber found that HVO soldiers used trucks to transfer these civilians, fired into the air to force the Muslims to get onto the trucks, and later forced them to walk on foot under military escort. Prlić fails to demonstrate any error in these findings. As for the necessity of relocating civilians, the appeals chamber recalls that the displacement of a population cannot be justified where it is caused by a humanitarian crisis resulting from the accused's own unlawful activity. The trial chamber found that Prlić shared responsibility for the harsh conditions of detention, that the transfer took place when there was no fighting in the area, and that there was no possibility of return. The appeals chamber identifies no errors in these findings and rejects Prlić's appeal. The appeals chamber now turns to the appeals concerning the wanton destruction of cities, towns, or villages, or devastation not justified by military necessity. The trial chamber found that throughout the day on 8 November 1993, an HVO tank fired at the old bridge of Mostar, rendering it on the verge of collapse by the evening. The trial chamber also found that the old bridge was essential for combat activities and that at the time of the attack it was a military target, given that its destruction would cut off practically all possibilities for the ABIH to continue its supply operations. The destruction of the old bridge resulted in virtually total isolation of certain residents and had a significant psychological impact on the Muslim population of Mostar. And the trial chamber therefore concluded that the impact of the destruction was disproportionate to the concrete and direct military advantage expected. The trial chamber also found that the HVO destroyed the old bridge in order to sap the morale of the Muslim population, and therefore concluded that the HVO committed wanton destruction not justified by military necessity. Stoic, Prlić, and Petković challenge the trial chamber's findings concerning this event. Stoic alleges that the trial chamber focused on actual harm rather than reasonably anticipated harm, failed to analyze the harm caused in terms of tangible injuries, and should have placed more weight on the old bridge's crucial importance as a military objective. Prlić and Petković also submit that the trial chamber erred in assessing proportionality. The prosecution responds that Stoic, Prlić, and Petković have not shown an error, that the trial chamber did not give insufficient weight to the anticipated military advantage, and that the trial chamber appropriately considered that the HVO's primary aim was to cause psychological and physical harm of the population. The appeals chamber finds, Judge Pokar dissenting, that since the old bridge was a military target at the time of the attack, and thus its destruction offered a definite military advantage, it cannot be considered in and of itself as wanton destruction not justified by military necessity. In the absence of any destruction of property not justified by military necessity in the trial chamber's legal findings, the appeals chamber concludes, Judge Pokar dissenting, that a requisite element of the crime was not satisfied and therefore overturns the finding that, in this case, the prosecution proved that destroying the old bridge constituted the crime of wanton destruction of cities, towns, or villages, or devastation not justified by military necessity. The trial chamber relied on these findings as a basis to find that the HVO committed persecution and unlawful infliction of terror on civilians when it destroyed the old bridge. At the appeal hearing, the appeals chamber invited submissions as to what impact an error on wanton destruction would have on these other two crimes. In light of the trial chamber's finding that the HVO had a military interest in destroying the old bridge and that it was a military target, the appeals chamber finds that no reasonable trier of fact could have found that the HVO forces had the specific intent to discriminate or the specific intent to commit terror when it destroyed the old bridge. The appeals chamber reverses, Judge Pokar dissenting, the trial chamber's finding that the destruction of the old bridge constituted persecution and the unlawful infliction of terror on civilians, and acquits the defense appellants of these crimes in relation to the old bridge. The appeals chamber also considers that these conclusions warrant the reversal of the trial chamber's further finding that Prlić knew about HVO crimes in destroying the old bridge and contributed to the JCE by attempting to minimize or deny this criminal destruction. The trial chamber further found that the HVO laid siege to East Mostar from June 1993 to April 1994, confining the population to a crammed enclave. The population could not leave East Mostar and was forced to endure extremely harsh conditions without food, water, electricity, or appropriate medical care, while the HVO subjected East Mostar to intense and uninterrupted shelling, engaged in a campaign of sniper fire, deliberately targeted members of international organizations, and hindered or blocked humanitarian aid. The trial chamber concluded that these actions were specifically intended to discriminate against the Muslims of Mostar municipality and to inflict terror on the civilian populations. Stoic, Prlić, and Petković contest these and related findings. They fail to demonstrate any error by the trial chamber. The appeals chamber dismisses their challenges. The trial chamber also found that during attacks, the HVO targeted and destroyed or significantly damaged 10 mosques in East Mostar, as well as Muslim property in Prose municipality. The trial chamber, however, overlooked its finding that these incidents did not qualify as a grave breach of the Geneva Conventions and neglected to enter convictions for wanton destruction as a violation of the laws or customs of war. This was an error, and the appeals chamber allows the prosecution ground of appeal in this respect, but declines to enter new convictions on appeal. With respect to the attacks in Gorny Vakuf municipality in January 1993, the trial chamber found that the HVO attacked 4 villages, including Dusha, which the HVO shelled indiscriminately, thereby killing 7 civilians. The trial chamber found that the attack on Dusha was indiscriminate because the HVO first used weapons, more specifically shells, the nature of which makes it impossible to distinguish military from civilian targets, and second, made no efforts to allow the civilian population to flee. Stoic and Prlić argue that the trial chamber erred when concluding that shells are inherently indiscriminate, and in disregarding that the house destroyed by the HVO in Dusha was a legitimate military target. The appeals chamber finds that the trial chamber's conclusion in relation to the nature of shells was not based on any evidence that the weapons used during the attack were inevitably indiscriminate. Absent such a basis, the appeals chamber reverses the finding that shells are inherently indiscriminate. The trial chamber's remaining finding is insufficient for a reasonable trier of fact to conclude that the attack on Dusha was indiscriminate. Because the trial chamber's reasoning with respect to Dusha applied equally to the attack on the other 3 villages, the appeals chamber also reverses the finding that these attacks were indiscriminate. The trial chamber relied on the indiscriminate nature of this attack to substantiate its finding that the HVO had the mens rea for murder and willful killing. The prosecution argues that the trial chamber reasonably rejected the arguments that the HVO aimed at legitimate military targets, and if the attack was not indiscriminate, then it was a deliberate attack on civilians. Given the combat activity and the position of the defenders of the village, the appeals chamber finds that no reasonable trier of fact could have concluded that the HVO forces in Dusha possessed the mens rea for murder and willful killing. The trial chamber's factual error occasioned a miscarriage of justice, and the appeals chamber reverses the subsequent findings and convictions in relation to the killings in Dusha. The appeals chamber also reverses the trial chamber's findings on the wanton destruction of property during the attacks on the 4 villages on the same day and related convictions for persecution. The reversal of the findings in relation to the Dusha killings also impacts the trial chamber's conclusion that the HVO engaged in a clear pattern of murderous conduct from January until June 1993, when the siege of Mostar, East Mostar, started. The appeals chamber therefore considers that the trial chamber's remaining findings establish that willful killing and murder were part of the JCE's common criminal purpose only as of June 1993 and not from January 1993 until June 1993. Consequently, the appeals chamber reverses the defense appellant's conviction for the murder of 2 unarmed men in April 1993 in Tuscany, Prose, Municipality, as being outside the scope of the JCE. The appeals chamber also finds that this reversal impacts the reasonable of the trial chamber's conclusion that Prlić could have foreseen the possible commission of these crimes and other murders that took place in April 1993 and willingly took this risk, and reverses this conclusion. The trial chamber also found that following these attacks on Dusha and other villages, HVO soldiers set fire to the houses of Bosnian Muslims, illegally arrested and detained civilians, and forcibly removed and unlawfully displaced women, children, and elderly persons. Prlić appeals against these findings. However, he fails to substantiate his allegations of error, and his arguments are therefore dismissed. I now turn to the trial chamber's findings on the JCE and the responsibility of defense appellants pursuant to the first and third categories of this mode of liability. The appeals chamber's considerations of these grounds of appeal amounts to the majority of the appeal judgment. For the sake of brevity, I will focus only on key outcomes. Before doing so, I note that in the light of his dissenting opinion on the scope of the JCE charged by the prosecution, Judge Pokar does not join the majority opinion with respect to its findings that counts 2, 3, and 21 constitute JCE 1 crimes. I first address the defendant's contention concerning the existence of JCE liability in customary international law. Prlić, Prlić, Chau, and Prose maintain that there are cogent reasons for the appeals chamber to depart from its prior jurisprudence that JCE, in all its forms, was a mode of liability firmly established in customary international law at the relevant time. They have failed to demonstrate any such cogent reasons, and their contentions are dismissed. Turning next to how the trial chamber described the ultimate purpose of the JCE, Prlić, Stoic, Prlić, and Prose challenged the trial chamber's finding that this ultimate purpose was shared by Franjo Tudjman and other leaders and was aimed at setting up a Croatian entity that reconstituted earlier borders and that facilitated the reunification of the Croatian people. The appeals chamber finds that they have not demonstrated that the trial chamber misinterpreted the relevant evidence, disregarded any evidence, or otherwise erred in reaching its conclusion. They, along with Petković, also allege a variety of factual errors underpinning the trial chamber's conclusion concerning the ultimate purpose of the joint criminal enterprise. Their arguments are lacking in merit and are dismissed. All 6 defense appellants challenge the trial chamber's conclusion that the common criminal purpose shared by the JCE members was the, quote, domination by Croats of the Croatian Republic of Herzegovina through ethnic cleansing of the Muslim population, unquote. In particular, they allege errors with regards to this definition of the common criminal purpose. The trial chamber's approach to its scope and subsequent expansion, and the findings on the stages of implementation. Despite the extent of their appeals, none of the defense appellants demonstrate any error of fact or law in the trial chamber's consideration of these issues. Prlić challenges the trial chamber's finding that he was a principal member of the JCE and that he significantly contributed to it from January 1993 to April 1994, including through his involvement in blocking humanitarian aid as well as in the mass arrests of Muslims the participation in planning the attack on Gorny Vakuf municipality, the eviction and movement of the population, and the concealment of crimes. Prlić submits that the trial chamber erred with respect to his powers in both civilian and military matters, the ways in which he significantly contributed to the JCE, his intent, and his ability to foresee crimes not within the scope of the JCE and willingness to accept this risk. The appeals chamber finds no such error and dismisses his appeal in this respect. Stoic alleges that the trial chamber erred in finding that he commanded and had effective control over the HVO and its military police, that he failed to prevent and punish their crimes, that he used the HVO and its military police to commit crimes, and that he significantly contributed to the JCE. Stoic also challenges the trial chamber's findings on his knowledge of crimes in the various municipalities and detention centers. Having examined his arguments, the appeals chamber finds that he fails to establish that the trial chamber reached its conclusions in error. However, the appeals chamber grants his appeal of the finding that he learned and accepted that civilians who were relocated from Prose Secondary School were being detained in Ljubuški prison in July 1993, but considers that this does not affect his overall responsibility for these crimes as a member of the JCE. The appeals chamber also finds that the trial chamber failed to provide a reasoned opinion on Stoic's intent for the crime of unlawful infliction of terror on civilians, but concludes that Stoic fails to show how this error invalidates his conviction for this crime. Nor has Stoic demonstrated any error in the trial chamber's findings that he specifically intended to discriminate against the Muslim population, intended to commit crimes in various municipalities and detention centers, and willingly took the risk that rape, sexual assault, and thefts would take place. His appeals are dismissed. Prlić appeals the findings that he wielded command authority over the HVO and its military police, that he was a conduit between the Croatian government and the HVO in furtherance of the JCE, and that he significantly contributed to the JCE with the requisite intent. He also challenges the trial chamber's conclusions concerning his involvement, knowledge, and intent for crimes committed in various municipalities and detention centers. The trial chamber stated that when Prlić relinquished his functions within the HVO main staff on 9th November 1993, he ceased to be a member of the JCE. The trial chamber, however, failed to provide a reasoned opinion as to whether it convicted him for crimes occurring after 9th November 1993. In particular, the destruction of 7 mosques in East Mostar that could not reasonably be found to have occurred before this date. and also sniping incidents committed in East Mostar the following year. The Appeals Chamber finds that Prlić cannot be held responsible for crimes occurring after 9th November 1993. The Appeals Chamber also finds that the trial chamber failed to provide a reasoned opinion on Prlić's intent for the crime of unlawful infliction of terror on civilians, but concludes that Prlić fails to show how this error invalidates his conviction for this crime. The Appeals Chamber also grants Prlić's appeal that no reasonable trier of fact could have concluded that he facilitated the murders and property destruction that took place in Stupni Do, Vareš Municipality, on 23rd October 1993. Prlić, however, has not demonstrated an error in the finding that he participating in the planning and direction of the operations in Vareš Municipality, and the Appeals Chamber affirms his contribution in this regard. The remainder of Prlić's challenges are dismissed. Petković contends that the trial chamber erred with regard to his powers and functions, his involvement in crimes committed in municipalities and detention centers, his intent, and his ability to foresee crimes not within the scope of the JCE, and willingness to accept this risk, as well as his responsibility for crimes committed by certain groups. With respect to the murders and property destructions in Stupni Do, as well as arrests of Muslim men in Vareš town, the Appeals Chamber finds that there was insufficient support for a reasonable trier of fact to conclude that Petković directly contributed to these crimes. This has no impact, however, on the trial chamber's findings that Petković was informed of these crimes, failed to take measures against the perpetrators, launched a fake investigation with regard to Stupni Do, and accepted these crimes. The Appeals Chamber also finds that the trial chamber erroneously concluded, without referring to any evidence, that Petković knew that the Bruno Busic regiment committed crimes in Gornji Vakuf municipality in January 1993, even though there was sufficient support for its conclusion that Petković learned of the regiment's crimes 3 months later. The Appeals Chamber reverses the finding that Petković contributed to the regiment's crimes by ordering its redeployment while knowing of the crimes it committed before April 1993. Finally, the Appeals Chamber grants Petković's appeal as to his responsibility based on the first category of JCE responsibility for the destruction of 2 mosques that occurred before the trial chamber found that destruction and or willful damage to religious institutions was part of the JCE's common criminal purpose. The findings of the trial chamber, however, support responsibility for the destruction of these mosques pursuant to the 3rd category of JCE responsibility, and the Appeals Chamber finds that Petković is so responsible. Petković's appeal is otherwise dismissed. Prlić challenges the trial chamber's finding relating to his JCE contribution as well as his mens rea. That is, both his intent and his ability to foresee crimes not within the scope of the JCE, combined with his willingness to take the risk. The Appeals Chamber observes that he repeats arguments that were unsuccessful at trial without any demonstration that their rejection by the trial chamber constitutes an error warranting appellate intervention. Prlić also regularly fails to identify the findings that he purports to contest. He misrepresents the trial chamber's factual findings and puts forward arguments that are undeveloped or underdeveloped, irrelevant or obscure. With respect to his submissions that are in accordance with the standard of appellate review, the Appeals Chamber finds that they fail to demonstrate an error. In particular, he has not demonstrated any error in the trial chamber's conclusion concerning his powers, his involvement in HVO detention centers, and his involvements in other crimes committed in municipalities. Prlić's challenges are therefore dismissed. Prlić appeals against the trial chamber's finding that he was a member of the JCE from April 1993 until April 1994, which the trial chamber based on his powers and contributions to crimes in the HVO network of detention centers through prisoner exchanges and in various municipalities, his spreading of false information in relation to HVO crimes and his intent. The Appeals Chamber finds merit in some aspects of his appeal and accordingly overturns 3 findings of the trial chambers with respect to Prlić's contribution to the joint criminal enterprise. Nevertheless, the Appeals Chamber upholds a majority of the trial chamber's findings, including those which formed the bedrock for the trial chamber's conclusion that he significantly contributed to the JCE. These related to his role in organizing the release of Muslim detainees to ABIH-held territories or to third countries, and his role as the link between the network of HVO detention centers and the most important JCE members. The Appeals Chamber finds that Prlić has failed to demonstrate an error in the trial chamber's conclusion that he contributed significantly to the JCE and intended the crime which formed part of it. Turning now to the prosecution appeal, the prosecution argues that the trial chamber erred in assessing the appellant's responsibility pursuant to the 3rd category of JCE responsibility. All 6 defense appellants respond that these acquittals were appropriate. The Appeals Chamber considers Judge Liu dissenting that a close examination of the trial chamber's judgment reveals that the trial chamber frequently used language indicating the use of an incorrect foreseeability standard for this category of JCE responsibility. In light of the context and manner in which the trial chamber used the terminology in question, at least with respect to the incidents specifically challenged by the prosecution, the Appeals Chamber finds, Judge Liu dissenting, that when assessing foreseeability, the trial chamber applied a higher threshold than required by correct legal standard. This was an error of law. The Appeals Chamber also finds, Judge Liu dissenting, that the trial chamber committed an error of law by failing to provide a reasoned opinion for why it found Prlić, Stoic, Prlić, Petković, and Ćorić not responsible for numerous crimes pursuant to the third category of joint criminal enterprise. Collectively, these errors concern Prlić's alleged responsibility for 26 separate incidents of murder, sexual violence, theft, and destruction of mosques. Stoic's alleged responsibility for 30 such incidents. Prlić's alleged responsibility for 32 such incidents. Petković's alleged responsibility for 18 such incidents, with the exception of destruction, except none for the destruction of mosques. And finally, Ćorić's alleged responsibility for 31 such incidents, and Prosić's alleged responsibility for 35 such incidents. The prosecution requests that the appeals chamber correct these errors, engage in a de novo review, find that requisite elements are met, overturn the acquittals, convict the defense appellants, and increase their sentences accordingly. In the alternative, the prosecution asks the appeals chamber to exercise its discretion to remand this issue to a bench of the tribunal to apply the correct legal standards to the trial records. The appeals chamber observes that if it were to conduct its own review of the relevant evidence and factual findings of the trial chamber, it would have to make findings on each of the 6 defense appellants' responsibility for the numerous incidents involving 4 different types of crimes that occurred in 6 municipalities and 3 detention centers over a period of 11 months. Moreover, the evidence concerning mens rea is of a circumstantial nature pertaining to the conduct, knowledge, and intent over more than a year in various locations. Conducting such an analysis would amount to a re-evaluation of the entire trial record and, in effect, require the appeals chamber to decide the case anew. However, an appeal is not a trial de novo, and the appeals chamber cannot be expected to act as a primary trier of fact. The appeals chamber accordingly declines to determine whether the elements of the third category of JCE liability are met with respect to the incidents at issue. Moreover, taking into account inter alia the protracted length of the proceedings, which have been ongoing for more than 13 years, with sentences ranging from 10 to 25 years of imprisonment, the appeals chamber also declines to order a retrial or remit limited issues for further proceedings. With respect to certain incidents concerning the killing of persons who were detained, the appeals chamber finds, Judge Liu dissenting, that the prosecution has shown that all reasonable doubt as to Prlić's and Petković's guilt under the third category of JCE responsibility has been eliminated, and that no reasonable trier of fact could have acquitted them for these crimes. Thus, the trial chamber committed errors of fact. The appeals chamber declines to enter new convictions in this regard on appeal. The prosecution also alleges that the trial chamber failed to adjudicate the superior responsibility of Prlić, Stoic, Petković, and Ćorić, who respond either that there was no such error, or that it would be unfair to remedy the error by entering a conviction on appeal. The Appeals Chamber recalls that when an accused is charged cumulatively under both Articles 7.1 and 7.3 of the statute, the trial chamber is legally required to make findings as to whether the accused incurred superior responsibility. The Appeals Chamber finds that the trial chamber erred by failing to make such finding on whether Prlić, Stoic, Prlić, Petković, and Ćorić bear superior responsibility for failing to punish certain crimes. The Appeals Chamber grants this aspect of the prosecution's appeal. However, it declines to embark on a de novo determination of their superior responsibility or to order a remittance or retrial of this case for that purpose. The trial chamber did not find Ćorić, the trial chamber did find Ćorić responsible as a superior for crimes committed in Prose Municipality in October 1992, specifically for the destruction of around 75 Muslim homes and other property, as well as theft of vehicles. Ćorić disputes the trial chamber's assessment of the evidence, as well as its findings that he exercised effective control over the perpetrators, knew or had reason to know of the crimes, and failed to punish his subordinates. The Appeals Chamber finds that Ćorić has not demonstrated any error by the trial chamber and dismisses his appeal accordingly. Ćorić also alleges that the trial chamber erred by entering convictions cumulatively for grave breaches of the Geneva Conventions and violations of the laws or customs of war, as well as for war crimes and crimes against humanity. The Appeals Chamber finds that he misinterprets the well-established legal standard that convictions can be entered where there is a materially distinct element for the same set of crimes, and that he fails to demonstrate any error by the trial chamber in entering such convictions in this case. His argument is dismissed. Sentencing. Turning now to sentencing, all parties except for Prlić appealed. The Appeals Chamber finds merit in the prosecution's argument that the trial chamber failed to take into account Ćorić's superior responsibility in sentencing. The Appeals Chamber dismisses all other grounds of appeal raised by the prosecution as well as by the defense appellants concerning gravity, aggravating circumstances, mitigating circumstances, and comparisons to sentencing practices in the former Yugoslavia and to other cases. As for the calculation of time already served, Stoic, Petković, Ćorić, and Prlić submit that the trial chamber wrongly excluded their time spent on provisional release, including while being under home confinement or receiving medical treatment. The Appeals Chamber recalls that Rule 101C of the rules provides that credit shall be given for the period, quote, during which the convicted person was detained in custody, unquote, pending surrender, trial, or appeal. The Appeals Chamber considers Judge Liu dissenting in part that the provisional release imposed on Stoic, Petković, Ćorić, and Prlić fall short of being tantamount to detention in custody and therefore rejects their submissions that the trial chamber erred when it excluded the periods of their provisional release when calculating the time that they already served as being detained in custody, while being detained in custody. Finally, with regard to the impact of the appeals chamber findings on the sentence imposed by the trial chamber, the appeals chamber has taken into account the extent to which it has reversed certain convictions and findings of culpability for all 6 defense appellants. All 6, however, remain convicted of numerous and very serious crimes. I shall now read out the full operative text of the appeals chamber disposition. For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the arguments presented at the appeal hearing on 20 to 24 and 27 to 28 of March of this year, sitting in open session, Mr. Prlić, will you please stand? With respect to Jadranko Prlić, dismisses Prlić's appeal in its entirety, reverses as a result of granting Stoic's sub-ground of appeal 45-1 and Prlić's ground of appeal 2, Prlić's convictions as a participant in JCE for, first, persecution, murder, and inhumane acts as crimes against humanity, and willful killing and inhumane treatment as grave breaches of the Geneva Conventions with regard to the killing of 7 civilians in Dusha, Gorny Wakuf Municipality. That's count 1, 2, 3, 15, and 16 all in part. Secondly, murder as a crime against humanity and willful killing as a grave breach of the Geneva Convention for the killing of 2 unarmed men in Tuscany, Prose Municipality, that is count 2 and 3 both in part, and 3, murder as a crime against humanity and willful killing as a grave breach of the Geneva Conventions for the murders linked to detentions committed in Jablanica Municipality in April 1993, counts 2 and 3 both in part. Reverses as a result of allowing the additional ground of appeal submitted by variously Prlić, Stoic, Prlić, and Chau in response to the prosecution's ground of appeal 3, Prlić's convictions as a participant in JCE 4, first, persecution as a crime against humanity in relation to destruction during attacks of houses in Gorny Wakuf Municipality on 18th January 1993, that is count 1 in part, and 2, Judge Pokar dissenting, persecution as a crime against humanity and unlawful infliction of terror on civilians as a violation of the laws or customs of war in relation to the destruction of the old bridge of Mostar, counts 1 and 25, both in part. Reverses, proprio motu, Prlić's conviction as a participant in a JCE for extensive destruction of property not justified by military necessity and carried out unlawfully and wantonly as a grave breach of the Geneva Conventions in relation to the destruction of houses and buildings in Vareš Municipality, count 19 in part. Affirms Judge Liu dissenting with respect to count 25 and Judge Pokar dissenting in part with respect to counts 2, 3, and 21, the remainder of Prlić's convictions under counts 1 to 13, 15 to 16, 18, 19, 21 to 25. Allows Judge Liu dissenting the prosecution's ground of appeal 1C concerning Prlić's responsibility as a participant in a JCE for the incidents as set out in paragraphs 3079 and 3114 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or remittance. Allows Judge Liu dissenting the prosecution's ground of appeal 1E in part, and finds Judge Liu dissenting that the trial chamber incorrectly found Prlić not guilty for committing, through his participation in a JCE, murder as a crime against humanity and willful killing as a grave breach of the Geneva Conventions with respect to the killings of 1. A Muslim detainee in Retrial prison on 16 July 1993, a detainee in Voino Detention Center of 5th December 1993, counts 2 and 3, both in part, but declines to enter new convictions against him in this regard. Allows the prosecution ground of appeal 2 concerning Prlić's superior responsibility for the incidents as set out in paragraphs 3134 and 3151 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or remittance. Allows the prosecution ground of appeal 3 in part, and finds that the trial chamber erred by failing to enter convictions for wanton destruction of cities, towns, or villages, or devastation not justified by military necessity as a violation of the laws or customs of war with respect to the destruction during attacks of first Muslim property in Prose Municipality between May or June and early July 1993, and secondly, mosques in East Mostar Municipality between June and December 1993, count 20 in part, but declines to enter new convictions against Prlić in this regard. Dismisses the prosecution appeal concerning Prlić in all other respects, affirms the sentence of 25 years of imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Prlić, you may be seated. Mr. Stoic, will you please stand? With respect to Bruno Stoic, grants Stoic's subground of appeal 45.1 and reverses his conviction as a participant in a JCE for persecution, murder, and inhumane acts as crimes against humanity and willful killings, and inhuman treatment as grave breaches of the Geneva Conventions with regard to the killing of 7 civilians in Dusha, Gornivakov Municipality. That's counts 1, 2, 3, 15, and 16, all in part. Dismisses Judge Liu dissenting in part and Judge Pokar dissenting in part, Stoic's appeal in all other respects. Reverses as a result of granting Stoic's subground of appeal 45.1 and Prlić's ground of appeal 12, Stoic's conviction as a participant in a JCE for murder as a crime against humanity and willful killing as a grave breach of the Geneva Convention for the killing of 2 unarmed men in Tuscany, Prose Municipality, counts 2 and 3, both in part. Reverses as a result of allowing the additional grounds of appeal submitted by variously Prlić, Stoic, Prlić, and Ćorić in response to the prosecution's ground of appeal 3, Stoic's convictions as a participant in a JCE for persecution as a crime against humanity in relation to the destruction during attacks of houses in Gorny Vakuf Municipality on 18th January 1993, count 1 in part, and 2, Judge Pokar Dissenting, persecution as a crime against humanity and unlawful infliction of terror on civilians as a violation of the laws or customs of war in relation to the destruction of the old bridge of Mostar, counts 1 and 25, both in part. Reverses proprio motu Stoic's conviction as a participant in a JCE for extensive destruction of property not justified by military necessity and carried out unlawfully and wantonly as a grave breach of the Geneva Conventions in relation to the destruction of houses and buildings in Vares Municipality, count 19 in part. Reverses proprio motu Stoic's conviction as a participant in a JCE under JCE 3 responsibility for murder as a crime against humanity and willful killing as a grave breach of the Geneva Conventions with respect to the killings of detainees from the heliodrome during forced labor or while being used as human shields, but affirms his convictions for the same crimes in relation to these killings under JCE 1 liability. That's counts 2 and 3 both in part. Affirms Judge Liu dissenting with respect to count 25 and Judge Pokar dissenting with respect to counts 2, 3 and 21, the remainder of Stoic's conviction under counts 1 to 13, 15 to 16, 18 to 19, 21 and 25. Allows Judge Liu dissenting the prosecution ground of appeal 1A and 1C concerning Stoic's responsibility as a participant in a JCE for incidents as set out in paragraphs 3018 and 3030 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or a remittance. Allows the prosecution's ground of appeal 2 concerning Stoic's superior responsibility for the incidents as set out in paragraphs 3134 and 3151 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or remittance. Allows the prosecution's ground of appeal 3 in part and finds that the trial chamber erred by failing to enter convictions for wanton destruction of cities, towns or villages or devastation not justified by military necessity as a violation of the laws and customs of war with respect to the destruction during attacks of, first, Muslim property in Prose Municipality between May or June or early July 1993. Secondly, mosques in East Mostar Municipality between June and 15th November 1993, that's count 20 in part, but declines to enter new convictions against Stoic in this regard. Dismisses the prosecution's appeal concerning Stoic in all other respects. Affirms the sentence of 20 years of imprisonment subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Stoic, you may be seated.
Kindly slow down for the purposes of interpretation. Thank you.
I will try to slow down. Mr. Prlić, thank you for standing. With respect to Slobodan Prlić, grants ground of appeal 12 and reverses his conviction as a participant in a JCE for persecution, murder, and inhumane acts as crimes against humanity, and willful killing and inhuman treatment as grave breaches of the Geneva Convention with regard to the killing of 7 civilians in Dusha, Gorny Vakuf Municipality. That's counts 1, 2, 3, 15, and 16 all in part. Grants Prlić sub-ground of appeal 44-1 in part to the extent that it concerns Prlić's responsibility as a participant in a JCE for the incidents as set out in paragraph 2003 of this judgment. Dismisses Prlić's appeal in all other respects. Reverses as a result of granting Stoic's sub-ground of appeal 45-1 and Prlić's ground of appeal 12, Prlić's convictions as a participant in a JCE for murder as a crime against humanity and willful killing as a grave breach of the Geneva Conventions for the killing of 2 unarmed men in Tuscany, Prose Municipality. Reverses as a result of allowing the additional grounds of appeal submitted by variously Prlić, Stoic, Prlić, and Chau in response to the prosecution's ground of appeal 3, Prlić's convictions as a participant in a JCE for first, persecution as a crime against humanity in relation to the destruction during attacks of houses in Gorny Vakuf Municipality on 18th of January 1993, and that's count 1 in part. And 2, Judge Pokar Dissenting, persecution as a crime against humanity and unlawful infliction of terror on civilians as a violation of the laws or customs of war in relation to the destruction of the old bridge of Mostar. Reverses proprio motu Prlić's conviction as a participant in a JCE for extensive destruction of property not justified by military necessity and carried out unlawfully and wantonly as a grave breach of the Geneva Conventions in relation to the destruction of houses and buildings in Vareš Municipality. Count 19 in part. Affirms Judge Liu dissenting with respect to count 25 and Judge Pokar dissenting with respect to counts 2, 3, and 21, the remainder of Prlić's convictions under counts 1 to 3, 6 to 13, 15 and 16, 18 and 19, and 21 to 25. Allows Judge Liu dissenting the prosecution's ground of appeal 1A and 1C concerning Prlić's responsibility as a participant in a JCE for the incidents as set out in paragraphs 3018, 3030, 3079, and 3114 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or a remittance. Allows the prosecution's ground of appeal 2 concerning Prlić's superior responsibility for the incidents as set out in paragraphs 3134 and 3151 of this judgment, but declines to quash the acquittals in this regard or to order a retrial or a remittance. Allows the prosecution ground of appeal 3 in part and finds that the trial chamber erred by failing to enter convictions for wanton destructions of cities, towns, or villages, or devastation not justified by military necessity, as a violation of the laws or customs of war with respect to the destruction during attacks of, first, Muslim property in Prose or Municipality between May or June and early July 1993. Second, mosques in East Mostar Municipality between June and 9th November 1993, count 20 in part, but declines to enter new convictions against Prlić in this regard. Dismisses the prosecution's appeal concerning Prlić in all other respects, affirms the sentence of 20 years of imprisonment subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Prlić, you may be seated. Stop, please. Please sit down. Mr. Petković, will you please stand with respect to Milivoj Petković? Grants Petković subground of appeal 5224 in part, and the prosecution's ground of appeal 1 in part, and reverses the trial chamber's findings that Petković was responsible as a participant in a JCE under JCE.
The problem here. Let's show a little bit of compassion. He's not in good position here.
I have taken poison.
Monsieur le Président, il vient. Notre client dit qu'il a bu un poison ce matin.
Okay. We suspend, please, the curtains.